Hi, Ray Dickey from Association Help Now. I am here with David Byrne, a well-known New Jersey HOA attorney, and we are going to talk about some of the new rules and regulations in regard to the Radburn Act. Correct, Dave?
If that's what you want to talk about, sure.
That'd be great. I thought we would do, Dave, is we'd go through a couple of quick PowerPoints, but we can go off in any direction that we need to go off. And what's going to be fun today is we're actually going to have some people on the line, and they're also going to ask some questions over the line also.
Okay.
So one thing I picked up on right away, there's all owners can vote. What exactly does that mean compared to how it was before?
I think I don't know that it's that much. It's that different. The amendments. It's owners can always voted in a normal association context, and that still exists now. There are differences, though, with respect to the type of voting that's involved. For instance, the Radburn law applies only to voting on board member elections, bylaw amendments, and any votes that are connected to special assessments or things that owners are asked to vote upon is not covered by these amendments. So that would still be subject to your existing governing documents and the like. So I don't know. All owners can vote. I mean, all owners always could vote, depending upon the governing documents and the like, subject to restrictions and limitations like good standing. Now there is, I think, the good standing part of the Radburn law is a big change. It helps to define what good standing means. So it removes it out of the discretion of the board. And even if there is a definition in that particular community's governing documents, which isn't always the case, or even if there is, it was sort of ambiguous oftentimes. The amendments do make the good standing limitation more defined, and that is really useful.
Owners can nominate themselves. Can you explain what is involved in that?
Well, it's funny because this Radburn law thing really stemmed from a community in North Jersey that was created a long time ago, and some of the issues that the new law was designed to address really don't have much relevance to what we deal with on a day-to-day basis. But it does make it clear that the board of an association, any association, is going to be limited in how it can create a sort of a threshold for being on the board. So an association could not preclude the candidacy of a member who is, in violation of some rule or such. That basically, as long as the owner is in good standing, as defined by the statute, then he or she could run on their own, i.e. self-nominate, or could nominate anybody else. There are some associations that especially ones that were created a while ago, that have like nominating committees and things like that. So to some extent, they're no longer really in play, to the extent that nominating committee had the power to limit who can run and who couldn't. Sometimes you'd have a situation where a candidate had to get 13 signatures or something like that. That if that was a rule, or if that was part of an association's governing documents, that would be gone. That is gone now.
Power of attorney must be honored. I saw that in the act. I don't understand it 100%. Can you explain it?
It's funny because in the context of this sort of environment, you do see the term power of attorney a lot. Owners use it, and board members are afraid of it, and it's interesting. In the context of this amendment, though, it's not. You don't need a power of attorney to vote on someone else's behalf. So if I'm an owner, I'm not available, I'd like someone else to vote on my behalf, I simply have to issue a proxy. Okay, and that was always the case. It's more protected now by virtue of the law, the proxy concept. But a power of attorney is going to be used more to the extent that the owner wants to assign his or her rights to pretty much everything in relation to the ownership of the unit, or perhaps even less than everything. But like if I own a unit and I live somewhere else, and my child lives in my unit, my child cannot technically be on the board, theoretically, because he or she's not an owner, but yet I could give that person a power of attorney, and I could make that person essentially me for the purpose of my rights and obligations vis-a-vis the unit. And that would then empower, in my hypothetical, the child to run for the board. And the laws in this regard is intended to sort of make it clear that to the extent you have a power of attorney and it's otherwise valid, that person would be able to run for the board.
I think let's go to one of our call-in questions. Lisa, do you have a question for Dave?
Yeah, I do. Good afternoon, you guys.
Hi.
We restrict how early a candidate may start to reach out to people for votes. Our residents just do not want to hear about the election every day. We have a candidate who is breaking this rule. How do we prove it, and how do we disqualify them? How do we draw the line between regular conversation and promoting oneself as a candidate?
Oh, that's sort of multi-layered question. I think in general that association really wouldn't be able to limit an ability of a member to talk to another person about the fact that they want to be on the board and or why. So even if the board were to adopt some kind of restriction like that, I don't even know how it would be enforceable. Practically speaking, I don't think it'd be enforceable legally either. I can't imagine something like that. The Raybern amendments are really about the way in which the association processes the election, not so much what an owner can and can't do in relation to their own candidacy. So, although the Raybern amendments require an association to affirmatively solicit people to run for the board, there's no limitation on a member of the association, trying to get people to vote for him or her before there's a solicitation. So I wouldn't even begin to recommend that a association attempt to limit the interactions between otherwise free people. I don't know how to even legally. I don't think it would play out, but I don't even know practically how you would even begin to do something like that.
Let's thank you, Lisa. Let's go to an email question. Can a power of attorney be used instead of a proxy? Is there a special format required, and does it have to be notarized?
Well, this is what I was kind of talking about before. If all you're interested in doing is having someone vote on your behalf because you're at work or you're, out away, you don't need a power of attorney. You just need a proxy. Though the amendments do open up the ability of a person to vote who isn't physically present, which basically means you don't really need a proxy anymore because the absentee ballot essentially solves your problem. So if you're unable to come to a meeting, you don't need to have your neighbor have your proxy. You just fill out an absentee ballot and send it in because the law now mandates the use of absentee ballots. But again, the power of attorney is more about the assignment of rights that sort of transcend voting. That would be about candidacy or the ability to make decisions about a unit. If there are, a good example would be, how a unit is going to be handled in like a repair or some reconstruction project, and an owner needs to be notified or needs to give waivers, needs to be involved in some respect. A power of attorney could be used and relied upon by the association. As to how you do a power of attorney, there's no regulation that it mandates how a board handles it. A power of attorney to be enforceable has to have certain elements to it, and it can be limited. It can be limited or it can be broad depending on how much the owner needed it to be. I think on a case-by-case basis is where the power of attorney will be relevant, and probably in this context you'd see it more when a non-owner wants to be on the board, and the owner would like that to be the case.
That kind of jumps us into the next email question a little bit. Does an association have to accept electronic formats in regard to power of attorney, proxies, and ballots?
Well, there's certainly no aspect of the new law that mandates an association's acceptance of a certain type of power of attorney. I mean, I guess an association could conceivably limit the validity of a power of attorney that is provided electronically because it's not an original signature, I suppose. I don't know that, I mean, I don't know that there'd be any interest in that. I mean, unless you really thought it was fraudulently produced or delivered, I don't know that it would have to be necessarily original. But the electronic format, I guess, is meaning the way people vote, sending it in electronically, and that's going to be allowed. The electronic voting is allowed if the board says it's okay and then the member agrees to it. So it's only on a case-by-case basis. So the board can create a mechanism by which voting electronically is acceptable. And then as long as an owner elects to do it in that fashion, consents to do it in that fashion, then they would have to accept that electronically submitted ballot. Did that answer the question?
It did.
Okay.
Let's go to Harry. Harry, I understand you have a question.
Yes, right. I noticed that the law makes a distinction between the size of associations, those that are under 50 and those that are greater than 50 units. And I wonder why that is and how that's being handled.
That's a good question. I think that the reason the law makes that distinction, I think, is the same reason that governments make distinctions with laws in general, where you're going to have some sort of mandate of some kind. You often see laws distinguish obligations based on size of business. So if there's a law that requires, I mean, Obamacare, I suppose, is a perfect example. There's a law that mandates an employer have certain health insurance available. I believe there's some cutoff that if you are a guy that owns a shoe store and you have two guys working for you, I don't think you have to provide health insurance or make it available. But if you own, Amazon, I think then you probably do. The concept being that larger businesses, in that example, would be more able to comply with the regulations. They can hire lawyers, they can hire accountants. They have the ability to comply with these, onerous obligations, whereas a small business person would be unable to. So I guess that's the concept here, being that if you're a small condominium, a small association, you're probably not professionally managed, meaning you're not managed by like a management company that has access to periodicals and lawyers and professionals that can help you navigate this minefield. So the concept is basically if you're fewer than 50 units, the statute sets out some minimal requirements, things that you have to do, but not specifically how you do them. And that's, I think, an attempt to balance the need for every association to operate in a certain way, but not burden a 15-unit condo in Belmar with the obligation of doing all this paperwork.
Okay, that makes sense.
Thanks, Harry.
I had just a follow-up on something earlier, right? The conversation about the absentee ballot. I may have missed part of that, but is an absentee ballot still permitted? From what you were saying, David, about power of attorney and the proxy.
Yeah, absentee ballots are definitely permitted. In fact, to some extent, they're mandatory. And it's interesting because I think the new law helps to address, or I guess maybe articulate a distinction that people had trouble with prior to this, which was the difference between a proxy and an absentee ballot. The governing documents and relevant statutes always contemplated the use and allowed for the use of proxies, never used the term absentee ballot. Mm-hmm. And the way practitioners and other people sort of handled that was by interpreting proxy as either a directed proxy or a general proxy. A directed proxy is an absentee ballot. It is basically, I'm submitting my vote in some form other than the physical meeting, but I'm directing you how to cast it. So essentially the person that takes the ballot is my proxy. And then a general proxy is one where I'm giving someone the right to vote on my behalf, but they theoretically could vote any way they want. And this law, these amendments, make it clear that there is a distinction between an absentee ballot and now a proxy, so that you have a proxy, it's when you give someone the right to vote on your behalf. And technically you're not really going to tell them what to do in that proxy, because otherwise you would just have an absentee ballot. There's no reason to have someone physically vote on your behalf when you can just fill out the form and send it. That's equally as valuable or valid.
Thanks, Harry.
Okay, thank you.
Process for nominations not to be less than 14 days. Can you explain what are the process requirements for
Right.
that?
Well, there's the Radburn amendments require associations to actually solicit candidates, or probably, I guess more appropriately, alert people to the fact that there is an election. And that requirement plays out in an obligation to send out a notice to people by saying, hey, there's an election meeting coming up. You have the right to either nominate yourself or nominate someone else, provided they're in good standing, et cetera, et cetera. And the 14-day requirement in that regard is that you have to you have to send out that request more than 14 days before the deadline. Otherwise, it'd be too last minute.
Let's go to Carol on the line. Hi, Carol.
Hi, how are you, Ray?
Good.
My question is really about the board term limits, David. Are there board term limits now because of Radburn? Does it change? Is there a maximum of that 4-year term, or is that just how many years you have and then you can keep running?
Right, it's a good question. The Radburn law has that 4-year language in it, but that's really about a term length, not number of terms. So the language prohibits a term of more than 4 years, but does not prohibit someone from serving many 4-year terms. So you can still be on the board for as long as you want, or as long as your neighbors decide that you should be on the board. So it's like,
Thank you.
so it's, some countries unlike our own that are maybe less democratic have terms of presidents which are like 13 years or something like that, and then that's designed. These amendments are designed to prohibit something like that, where someone gets to be on the board and they have a term of 10 years, and there's no way in which to have a transition of power.
So no board members for life.
Right, unless of course they win.
Right.
But their terms have to be less than 4 years.
Thanks, Carol.
You're welcome.
Back to some of the process. It makes a notation not less than 14 days for the election process. That seems like an awfully small amount of time for this all to happen. Can you explain why?
I think the 14-day language is relevant only to the solicitation of candidates, which we talked about before, and the notice of the actual election meeting. So the members have to receive notice of the election meeting not more than 60 days prior to the election date, but not less than 14 either. So if an election meeting is July 1st, you couldn't send the notice of the election meeting out on June 27th. You'd have to send it out before whatever June 1st minus 14 days will be. So the amendments are trying to make it so that people are going to get notice of this election meeting, not so last minute.
But it's 14 days at the point they start the process. So people still physically have to get something in the mail, right? And if they have to physically return a particular item.
Well, but that's only with respect to the candidate selections.
Right.
That's what. But that's requesting the person. That's requesting that the candidate return his or her interest in running. The solicitation to the candidates, I believe, the deadline has to be. Let me just check that. I'm going to check that real quick because it's interesting. Online. The period for submitting nominations shall not be less than 14 days from the mailing of the request of a nomination. So, if I send out a notice by saying, hey, you have the right to nominate yourself or nominate someone else, and by the way, you have to send those in within the next 48 hours. That's not lawful.
Mm-hmm.
You have to give the person at least 14 days to do it. See what I'm saying?
Is there any language about how long the election process can take? So they send out a ballot to people. When does the clock start? How much time do people
Well, you're
have
s-
to get a ballot back to make it
Oh, well,
valid?
the meeting is still the election moment, so you
Right.
still have a meeting, and I believe that the amendments require that association to accept the ballot up until I think it's up until the moment of the election, I believe. But I have to check the specific language too. If but I
And then
think-
we can follow up on the website too if we need to
Right.
add any additional information. So for the case of mail-in ballots, that could be difficult if there's not a lot of time for people to get the actual physical, they get the ballot in the mail.
Right, but
they
you-
need to fill it out.
it's got to be within 60 and 14 days. So
Right.
you could, I guess, send the absentee ballots and the notice out 30 days prior to the election meeting. That would be acceptable. Some governing documents, in fact, probably many of them, require votes to be in that are not going to be cast in person. Require votes to be in 3 days prior.
Mhm.
That's all eliminated by virtue of the amendments.
Let's.
I just don't remember if the deadline is the time of the meeting or if there's a requirement that they be accepted during the meeting. I have to check that.
Let's go to Lawrence, who's on the line. Hi, Lawrence.
Hi, Dave. Hi, Ray.
Hi.
The act refers to proxies and to proxy ballots. And it's not clear if there's a distinction between the two. I wonder what your views on it are. Do all the names have to be listed on an undirected proxy ballot?
Well, it depends on
and
what you.
would qualify?
Well, it depends on what you're. I think what we're talking about. An absentee ballot is going to go out, and it's going to have the candidates listed on them, and they have to be listed in alphabetical order. A proxy is going to be used, but that's not an absentee ballot, so that's not going to have anything on it other than some of the specific things that are required to be on proxies at this point, which would be that the proxy can be revoked any time before the meeting, and some other language. There are 3 things the statute mandates to be on a proxy. So by definition and by language of the statute, a proxy is not the same thing as a proxy ballot. A proxy is something you give someone to do something on your behalf, and there's no limitation on it other than the 3 things the statute lays out. But those have to be on a proxy that's used. The only thing a person's going to get is going to be a notice, an absentee ballot, and a proxy. So I don't know that I would use I don't know that proxy ballots are really anything of a significance, legal significance.
Did that answer your question, Lawrence?
Just to follow,
Sure.
No, just to follow up for a second. What does the phrase proxy ballot mean?
Well, which part of the statute are you?
Proxy
Which part of the statute are you looking at with that? Do you have a specific part of it?
Almost every part of the statute, only a few times does it use the phrase proxy.
Well, I don't.
For me to tell you what.
I'd have to look at that because I think I see absentee ballots and I see proxies. So I'll have to look for that distinction if you think it's there. But I see the use of the term absentee ballots and then I see the use of proxies. But I can look more thoroughly when I have a chance.
And then we'll follow up on the website on that. Thank you, Lawrence.
Okay.
We've already gone over the electronic voting. That was one of my key points. And we've actually already answered this question by a call-in. I noticed some language, the counting of ballots, report of disqualified votes, and why. You have to let the residents give them an explanation of which votes.
I don't think so. I think to some extent the Nonprofit Corporations Act still applies, and that statute is what creates the dynamic or the somewhat obligation of inspectors. And we're not judges, the word judge, but they use the word inspectors. Inspectors are not mandated by the new amendments, and inspectors are not really even mandated by the Nonprofit Corporations Act. They're mandated if an owner requests that they be used, or they're mandated if the governing documents of that particular community require it. But in the word inspectors is something that flows from the Nonprofit Corporations Act. So I'm not sure if there's what you mean by a report of disqualified votes and why. I don't know. I'd have to look at
There was some language
in the statute about that.
I thought I saw something about it. So, but we'll follow up on that on the website also. We'll check it out.
Okay.
change bylaws to match state, federal, local law. You don't need a vote on that, correct?
Well, there's a mechanism in the law that allows the board, without any oversight of owners, to amend the bylaws to the extent necessary to, be consistent with state, federal, local law. So I frankly, I don't know if an association would ever. This kind of thing to me would be like make work for lawyers, because to the extent a law already mandates something or makes something unlawful, you don't need to amend your bylaws to make it consistent. I mean, it is. So if there's a law that prohibits an association from discriminating against people in the use of a clubhouse on the basis of race, that's the law. You don't need to change your bylaws to make it that way. It already is that way. So I don't know that you would even need to do that. This one, you would, the 10% thing does provide an opportunity to communities that we didn't really have, and smart communities are to be the ones that try to take advantage of this. Now, obviously, it's well, let me talk about what it is first, I guess. This particular part of the Byrne law allows bylaw amendments to be valid and adopted if the board adopts them and not more than 10% of the people reject them. So if a board adopts an amendment, it has to give that amendment, that notice out to the members, which is, hey, the board's adopted this amendment. Just so you know, if you don't reject it within the next 30 days, it's going to be an amendment. It's going to be valid. That is a definite improvement, something that's going to help facilitate things that a community may want to do and was always unable to do it because the requirements of amendments in those particular government documents are always so high. Now, obviously, this type of this opportunity is only going to really be available for the amendment that's not controversial, because if 12% of the people say no, then it doesn't work. So it's, which is a very tiny minority. So it has to be something that people are either going to not care about when they see it, or it's something they're going to be in favor of. But if it's something like, that is going to make a big difference in people's lives, then they're probably going to vote no. And you only need 10% of people to vote no, and then it won't work.
Has the standard changed to, this was an email question, has the standard changed to 51% of eligible votes to change the bylaws?
No, the Byrne law says or provides that a community can amend its bylaws by 51% if there is no existing mechanism in the bylaws for them to be amended, which is unusual which will be unusual in the modern association context. The modern association, condominium or otherwise, is created by virtue of the master deed or declaration, and then a set of bylaws, and those are kind of all look the same. Whatever lawyer drafted them 50 years ago, they just keep recycling that form. So you're unlikely to see a set of bylaws that do not have a mechanism by which they can be amended. But if there is a set of bylaws that do not have a way to amend, then by default it's 51%. Or if those bylaws do have a mechanism to amend, but it's 2/3, then it's 51%. That make sense?
A little bit.
Okay.
So I'll rewatch the tape, and if it doesn't,
Okay.
we'll put it on the website
With subtitles.
Did you want to ask anything else, Dave? Add anything else before we let you go? I know we covered
the open-ended catch-all comment.
Yep.
About it. I think that the two most important aspects of the amendments are what we just talked about, which is the ability of associations to do bylaw amendments, pretty much on board member approval, assuming that they're relatively innocuous. And that will help with communities with things like provisions that have been difficult in the past. Like, for instance, the Condominium Act empowers a condominium to levy fines against owners, but only if the power to fine is either in the master deed or the bylaws.
Mm-hmm.
So if you somehow ended up in a community that had a master deed and bylaws, neither of which have the power to fine, you then can never fine. But if you need to amend your bylaws by virtue of 51% of vote, it's almost impossible to do. Not so much because people are against the amendment, but because people don't really care enough to vote. So this would then allow you to sort of clean up those things that have become necessary to be in your bylaws in order for you to effectively operate. Capital contributions have to be mentioned in bylaws or your governing documents. The ability to recover certain expenses like attorney fees, repair costs you may make vis-a-vis a unit that's in receivership or something like that. You can really add to your bylaws some things that are pretty innocuous to members. They're not going to be upset about that because they facilitate the interests of everyone. They're not punitive in some way. And then I think the other aspect of the law that's the amendments that's really important is the specific definition of good standing. Does, I think, remove a lot of ambiguity in that with that term. Probably makes less chicanery likely. Boards attempting to consider what they believe to be good standing or not to keep people from voting and that sort of thing. It lays out very specifically what's considered good standing and also addresses some of the more nuanced aspects of this, like people who may have delinquency in assessments but are on a payment plan and are in compliance. Or people that have a dispute with the association may have fines but have initiated some ADR, or there's some mechanism that's ongoing by which the dispute is going to be potentially worked out in some way. That person would still be in good standing. So it does try to remove the ability of boards to be a little more flexible with how that's defined, which of course then is going to hopefully mean less litigation, less election-related disputes.
Great, thank you so much, Dave. And I think what we'll do is we'll have our callers stay on the line,
Okay.
and we'll go offline here, and we'll post some of their questions and answers on the website also.
Okay.
So thanks for coming in, and
All right.
thank you to all our callers. Please stay on the line, and we'll let you wrap up with Dave with a few more questions. Thank you very much.
Thank you.